Reno County Grain Cooperative, Hutchinson, Kansas. Grain storage receipt. Number 4471. Date of deposit, October 8, 1984. Depositor, Helen Morrow. Commodity, hard red winter wheat. Quantity, 28,000 bushels. Grade, number 2. Reno County Grain Cooperative. Membership record. Active member since 1961. Member of record, Gerald Morrow. Account number 1847. 2 documents, same grain, different names. Helen Morrow held receipt number 4471 in the drawer where she kept important papers. Gerald Morrow held account number 1847 with the cooperative his family had belonged to for 23 years. In the fall of 1984, both of these facts mattered. They mattered in opposite directions. Helen and Gerald Morrow had been farming together in Reno County since 1968, the year they married, and Gerald took over management of his father's wheat operation. The farm was 480 acres of dryland, winter wheat ground in the Hutchinson district, carrying land that Gerald's father had purchased in 2 parcels in the 1940s and that Gerald had added to incrementally through the 1970s when prices and credit conditions permitted expansion. Helen had been part of the operation from the beginning. Before the marriage, she had worked for 3 years at a grain elevator in McPherson County, behind the scale ticket window, processing deliveries, managing the account records, and she had brought that knowledge into the Morrow operation from the first harvest season. She handled the books, managed the operating account at First National, where the crop loans were serviced, coordinated the crop insurance filings, and drove the grain truck at harvest when Gerald was still in the combine. She was not a support role. She was the operational half of a 2-person farming business. The cooperative membership, though, had always been in Gerald's name. His father had joined the Reno County Grain Cooperative in 1961, when the co-op had been organized by a group of Hutchinson district farmers as an alternative to the commercial elevator in town. Gerald had inherited the membership when he took over the farm in 1968, as naturally as he had inherited the equipment and the lease on the East Quarter. It had not occurred to either of them to add Helen's name to the membership because the membership was not something they thought about separately from the farm. It was simply the account where they sold wheat, the way the First National account was where they banked. The administrative detail of whose name was on the cooperative membership had never mattered because in 16 years of farming together, there had never been a reason for it to. By the fall of 1984, the marriage was failing. The specific circumstances that had brought them to that point were private. By October, they were occupying separate spaces in the house, communicating through notes, and each had spoken privately to attorneys. Helen had delivered the wheat in October. The harvest had come in at 42 bushels per acre on the home ground, a reasonable yield for a dryland operation in a year that had run drier than average. She had driven the grain truck to the cooperative herself, as she had done most years. She had watched the wheat auger into the bins, stood at the window while the sample was graded, and received the storage receipt when the transaction was complete. The receipt carried her name because she was the one who had driven in, who had handed over the samples, who had filled out the delivery paperwork. She was, as far as the cooperative's scale ticket system was concerned, the depositor on that transaction. She took the receipt home and put it in the drawer where she kept important papers. The following week, Gerald filed for divorce. 3 days after the filing, an attorney's letter arrived at the cooperative's manager's office. The letter identified the Morrow account at the cooperative as a marital asset that was the subject of a divorce proceeding, requested that the cooperative place a hold on the account pending the court's determination of the parties' respective interests, and specified that no grain should be released, sold, or proceeds distributed to either party without a court order or the written consent of both parties and their counsel. The cooperative's manager, a careful man named Tillman, placed the hold on account number 1847. He had handled similar requests during the farm crisis years, when creditors had asked for holds on accounts whose borrowers were in default proceedings. The procedure was straightforward. Hold the account, document the request, wait for a court order or a resolution. The 28,000 bushels of wheat sat in the elevator. Storage fees of $0.013 per bushel per month began accumulating. Helen called the cooperative the following Monday morning. She told Tillman she was calling about the storage account and that she wanted to sell the wheat before the price moved further in the wrong direction. Winter wheat had been trading near $3.40 a bushel at the time of delivery in October. By late November, it had softened to $3.18. She had a receipt in her name for 28,000 bushels. She wanted to authorize the sale. Tillman explained the hold. Helen asked why the hold applied to her grain. The receipt had her name on it. She had delivered the wheat herself. She could prove the deposit with the receipt she was holding. Tillman explained, with the patience of someone who had navigated similar conversations during the farm crisis years, that the grain storage account at the cooperative was held under account number 1847, which was registered to Gerald Morrow as the member of record. The storage receipt documented that Helen Morrow had delivered the grain and was the depositor, but the account that held the grain, the account through which the grain could be sold, moved, or released, was controlled by the member. Helen asked what that meant practically. Tillman said it meant that any authorization to sell or release the grain would need to come from the member of record or from a court order. The attorney's letter had requested a hold, and the cooperative's standard practice in a disputed marital situation was to honor such requests until the court resolved the underlying dispute. He was not taking a position on who owned the wheat. He was following the procedure that protected the cooperative from liability in a situation where two parties had claims that the court would need to sort out. Helen asked whether her receipt meant anything. Tillman said the receipt documented that she had deposited the grain. It was evidence of the deposit. It was not the same as authorization to release or sell the grain that had been deposited. A grain elevator cooperative's membership structure creates a legal framework that most people who interact with the elevator never need to think about, because most of the time it operates invisibly, in the background, and the member and the depositor and the account holder are all the same person. When a farmer delivers grain to his co-op, the grain goes into his account, and he is the member who controls that account, and he authorizes sales, and the proceeds come to him. The membership structure and the physical receipt point to the same person, and there is nothing to disentangle. When the member and the depositor are different people, or when the member is in an adversarial legal dispute with the depositor, the structure that usually operates invisibly becomes the mechanism that determines who can do what with the grain. A grain storage receipt documents a specific transaction, the delivery of a specific quantity and grade of a commodity by a named depositor to a licensed storage facility. The receipt is evidence of that delivery. It identifies the depositor. It specifies the commodity, the quantity, and the grade. It is issued to the person who physically effected the delivery. In many storage arrangements, the physical receipt is a negotiable instrument. It can be endorsed and transferred, and whoever holds it can claim the grain. In a cooperative elevator structure, however, the receipt's relationship to control over the grain is more complicated. The cooperative account is tied to membership. When a member deposits grain, or when a non-member deposits grain under a member's account, as Helen had done by driving the truck and delivering under account number 1847, the grain is held in the member's account. The account is the operative container. The receipt documents the deposit into that account. The member controls the account. The member authorizes releases. The member initiates sales. A depositor, who is not the member, the spouse, a business partner, a hired employee, can deposit grain into the account if the member has authorized them to do so, but they cannot unilaterally withdraw grain, authorize sales, or direct releases from the account without the member's participation. Helen had been depositing grain under account number 1847 for years. In normal circumstances, this had created no issue because she and Gerald were operating together, and any decision about the grain was a shared household decision that ran through Gerald's membership account as a practical matter. The receipt in her name documented her role as the delivery driver. The account in Gerald's name was where the grain lived. When Gerald filed for divorce and the attorney's letter placed a hold on the account, The structure that had operated seamlessly for 16 years revealed its architecture. The receipt documented what had been delivered. The membership controlled what happened next. These were separate things, and in a divorce proceeding, the separation mattered enormously. Helen's attorney contacted the cooperative in early December with a letter of his own. The letter argued that the grain delivered on October 8th was Helen Morrow's separate property, earned from her active participation in the farming operation, and that the storage receipt in her name was prima facie evidence of her ownership interest in the deposited commodity. The letter requested that the cooperative recognize Helen's authorization to sell the grain independently of the hold on Gerald's membership account. Tillman reviewed the letter with the cooperative's own attorney. The cooperative attorney's advice was consistent with what Tillman had already understood. The cooperative was not in a position to adjudicate the ownership dispute between the parties. Its obligation was to its member of record and to the court's direction in a legal proceeding. A storage receipt in Helen's name was evidence that she had delivered grain. Whether that evidence supported her claim to own or control the grain was a question for the divorce court, not for the cooperative's manager. Until the court resolved it, the hold would remain. The wheat sat in the bins through December and into January. Storage fees continued at 0.013 per bushel per month. On 28,000 bushels, the monthly charge was $364. By the time the divorce court's first hearing addressed the grain question in February 1985, 4 months of storage fees had accumulated, $1,456, charged against the account that neither party could currently control. The wheat price, meanwhile, had declined further. The November price of $3.18 at which Helen had wanted to sell dropped to $3.02 in December and reached $2.88 in January. The Reno County District Court's handling of the grain question was, in the context of the full divorce proceeding, a relatively minor issue. The parties' attorneys agreed in February 1985 to allow the grain to be sold, with the proceeds held in escrow by the court pending the final divorce settlement. Tillman received the agreed court order, and the cooperative processed the sale at the February market price. At $2.88 per bushel on 28,000 bushels, the gross proceeds from the sale were $80,640. After storage fees of $1,820 accumulated from October through the February sale date and the cooperative's transaction fee, the net proceeds held in escrow were $78,548. Helen's attorney had argued that the grain was her separate property and that she should receive the full net proceeds. Gerald's attorney had argued that the grain was a marital asset produced by the farming operation, which was jointly owned, and that Helen's role as the delivery driver did not establish a separate ownership interest. The court's final property settlement, issued in April 1985, treated the grain proceeds as marital property and divided them as part of the overall settlement. Helen received a portion of the $78,548, not all of it, and the amount she received was $18,900 less than she would have netted if she had sold the grain at the October price when she had first tried to do so. Before the hold, before the price decline, before the storage fees had accumulated, the storage receipt in her name had not been sufficient to authorize the sale. The membership structure had required the court's involvement to resolve the impasse. The resolution had taken 4 months and had cost, between price decline and storage fees, a meaningful fraction of the grain's value. The two documents that had opened this situation, the storage receipt and the membership record, had described different aspects of the same grain accurately. The receipt was right. Helen had delivered 28,000 bushels of hard red winter wheat to the cooperative on October 8, 1984. She was the depositor. The delivery happened. The grain was real. The membership record was also right. Gerald Morrow was the member of record on account number 1847. He had been the member since 1961. The account structure that the cooperative operated under made him the controlling party for releases and authorizations under that account. Neither document was wrong. Neither document was fraudulent. They had been produced by the normal operation of two separate systems: the delivery receipt system that documented what came in, and the membership account system that governed what could go out. These two systems had operated together smoothly for the entire 16 years of Helen and Gerald's marriage, because in all of that time, there had been no reason for their structure to matter. The member and the operating partner were making decisions together. The grain moved on terms both had agreed to. When they stopped agreeing, the structure became visible. The receipt documented her delivery. The membership controlled the release. Those were different authorities held by different people, and the distance between them cost 4 months of waiting, a price decline from $3.40 to $2.88, and $1,820 in storage fees on grain she had delivered herself.